Harry's story demonstrates several issues with mandatory minimum sentences. Impact on marginalized communities. First, let's talk about the impacts mandatory minimums have on marginalized folks, specifically racialized ones like Harry. Black, Indigenous, and people of color are drastically overrepresented in the Canadian criminal justice system. Scholars, academics, and lawyers have noted that this overrepresentation is due to deeply rooted racism and settler colonialism, creating conditions where people of color are more likely to commit crimes. Conditions like systemic poverty, lack of educational opportunities, etc.
The Truth and Reconciliation Commission's 30-second call to action highlights mandatory minimum sentences as a reason for this, because the offenses that Indigenous people are more likely to commit are those with mandatory minimums. In our story, Harry and his family's substance abuse issues can be traced back to the generational trauma of genocide and colonialism in Canada. Harry loses opportunities to connect with his culture and is forced into situations where he is given less choices. He turns to alcohol, making it more difficult for him to hold a job and forcing him to earn an income through crime. No matter how hard Harry tries, he does not have the same choices available to him as others. Because of these systemic issues, Harry cannot afford a good lawyer at first. He has to rely on legal aid, which is a government program that is often underfunded and overworked. Only when someone agrees to take his case on for free is he able to challenge the mandatory minimum sentence. This is an option available to very few.
Harry's experience in prison shows how hard it can be for some to get out of the criminal legal system. Because Indigenous people are more likely to end up in prison, and prisons foster a hostile environment, many offenders have less choices and reoffend either in prison or when they are released. This is called the revolving door effect of prison, which affects people of color much more than others because of some of the systemic issues we discussed earlier. Mandatory minimums make this worse by making sentences longer than they should be for certain offenders, as the longer one is in prison, the higher the chance that they will reoffend.
The power of prosecutorial discretion. Now, let's get into the power of prosecutors. Prosecutors are given a lot of discretion to choose what crime a person is charged with. This is especially true for hybrid offenses. Hybrid offenses are those that basically have two versions of the same crime: a summary offense, which is seen as less serious and has a lower sentence, and an indictable offense, which is seen as more serious and has a higher sentence. Prosecutors get to decide whether the crime someone committed is serious enough to be an indictable offense, even though it's still technically the same crime, and potentially increase the mandatory minimum sentence someone is faced with. Additionally, because prosecutors have so much discretion, we don't always know what might be happening to influence why a prosecutor decides to charge someone with a specific crime. It might depend on the background and experience of the prosecutor in charge of the case, or even on what is happening with their colleagues and supervisors. For example, the crime Harry is charged with is influenced by how Pooja and Marshall considered his run-ins with police and their potentially racist perspectives about crime within Indigenous communities.
What makes this even worse is that prosecutors' decisions are hard to challenge in court, needing extremely clear proof of shady behavior. Most of the time, there's not any extra review to make sure these decisions are made properly. This means that people can spend extra time in prison not because of the law itself, but because of how the prosecutor assigned to their case chose to handle it, something completely outside their control. This is a big problem, especially when you consider the fact that an accused person can challenge a judge's decision regarding the sentence they're given, and yet can't do so as easily with a prosecutor. Thus, to an extent, prosecutors can practically choose someone's sentence by charging them with a crime that has a mandatory minimum, without the same level of review attached.
Challenging mandatory minimums. Now on that note, let's talk a little bit about how difficult it is to bring a challenge to a mandatory minimum sentence. The main way mandatory minimum sentences are challenged is through the Hills test, which has many issues. Though most of us would believe that a sentence should be proportional to the crime a person commits, Canadian courts do not consider proportionality as what we in criminal justice communities refer to as a principle of fundamental justice.
In other words, Though it's still very important, it is not a value that goes to the very heart of ensuring that justice is done correctly. Because of this, a sentence can't just be disproportionate to be changed. It has to be grossly disproportionate to what the sentence should be, which is a very high bar to meet, and it has to offend the standards of decency outlined by the court, as we saw with one of Harry's appeals. This means that a 1-year difference may not be enough to overturn a sentence. However, this begs the question, whose standards are these? For many, 1 year in prison may still be disproportionate, especially if we have the perspective that locking someone up in prison is, by nature, cruel and unusual itself, which the Charter unfortunately does not recognize.
This idea of a mandatory minimum sentence needing to be grossly disproportionate also isn't reflective of how courts normally judge proportionality for other parts of the Charter, like Section 7, which focuses on the right to liberty, in this case not being in prison, and applies a much lower standard when it comes to deciding whether a sentence is proportionate or not. Finally, we come to the use of reasonable hypotheticals in cases where someone may want to try to strike down the mandatory minimum using a made-up offender who could, if they committed the crime, receive a grossly disproportionate sentence because of the mandatory minimum attached. In Harry's case, the major issue is the requirement that these hypotheticals be reasonably foreseeable. This is a very subjective idea that essentially depends on what the judges themselves think is realistic, which can be based just on the evidence before them and on their own personal experiences. For example, a white judge who grew up in an upper-middle-class household in downtown Toronto might not have the same ideas of what kinds of crime scenarios are realistic versus an Indigenous judge who grew up in a low-income, rural community. Thus, though the Supreme Court has given offenders a framework to challenge Parliament's decisions, this framework has its own set of problems worth being aware of.
We hope this short exercise has given you some of the tools required to think more critically about mandatory minimum sentences. Though it is important to keep mandatory minimums in mind when deciding whether or not to commit a crime, it's also important to remember that some of us have less choice than others to begin with.
This makes mandatory minimum sentences extremely unfair, as judges have much less of an ability to decide whether to reduce a sentence based on life circumstances that might make it more likely for some of us to commit crimes versus others, like the Gladue factors, which we saw couldn't be applied in Harry's case. Striking down mandatory minimums isn't impossible, but what we need is the political will to do so. That means all of us will need to speak up, so stories like Harry's become the exception and not the norm.